Hello everybody, I'm ASCAP's Eitan Rosenblum, and my guest for our first playback stage interview is Mr. Ken Abdo. Is it Esquire, Attorney at Law? What's your preferred?
All of those. I earned all those titles. I was actually a disco DJ for a while too, which I'll admit, and I'm proud of that. I liked it, still do. So I was an entertainer, but decided that wasn't my vocation, that probably was my avocation, and that I really wanted to be a counselor. So I ended up moving to the practice of law.
When a potential client first approaches you as a possible attorney or firm, what kind of services are they usually looking for in that stage?
I think that what people want to know is what are the protections they have for these creative things that they're creating. You know, what is it? It's a property. It's an intellectual property. It's the generic name, and they want to understand what that means because they know they've created something, and it's like having a child. You know, you've created this new thing, and what can you do to nurture it, protect it, and make it, have a long life? I think the biggest concern that most songwriters have are how do I establish what I own in the song, and then how do I protect it? Then beyond that, it becomes, things like if there's an infringement of the ownership rights in that song, then there might be a cease and desist letter. Or if somebody wholesales ripping it off and making money from it, it might turn into some litigation if you can't resolve it. But in its essence, it's about protecting and exploiting, and that's a good word, copyright. That's what songwriters do. They create copyrights in music compositions.
So give us a brief overview. I'll give you a scenario. You're a songwriter, you're collaborating with somebody for the first time. You've just written what you guys both think are a wonderful set of songs. Before you leave the room, is there something that you should do to protect your interests right then and there?
Yeah, I think that the protocols in co-writing are such that if you're in the room and you're making contributions to the melody or lyric of a song, that there's a co-writing moment. To what extent or what percentages that might be shared is to be negotiated. But there are some protocols like, hey, if we were both in the room, and it was just the two of us, and we built a song from the ground up together, it's basically a 50-50 assumption. But it could be different. Someone comes into the room and says, I have a song that I've started, I just can't get it over the finish line, then it becomes a different percentage. But yes, that should be realized as a good thing, as a common thing, and to write something down that says, okay, for this song, it's 50-50, or it's 20-80, or whatever. It doesn't have to be a big, long document. It can just be something very simple that acknowledges that split.
So that's not the kind of thing you need to hire an attorney for?
Not really. I think, there are forms that we sometimes provide clients that say, here's a basic collaboration, split agreement. But there are other rights beyond the ownership, like who has the right to exploit it? Okay, do both parties, can they find somebody to cover it, or does someone have the right to control that part of the exploitation? Okay? Who has the right to administer it? Say I'm a co-writer, I have a publishing deal or administration deal, you don't. Should my administrator or publisher be allowed to administer your portion of the song? So those can be addressed in a more elaborate agreement, but still those agreements aren't very big. They're not very long, and they are, again, subject to a lot of established protocols.